Good afternoon, everybody. I think we'll make a start, although there may still be people logging on. I'm Alice Reeve, and I'm joined today by my colleagues Nick Morell and Ellie Boyd. It's a focus on an employment law update for academies and schools. We're going to talk to the slides, and then there'll be plenty of time for questions. We are going to record it, and you'll have access to the slides and the recording after the event. If you do have any questions, please pop them in the Q&A box, and we'll go through them all at the end of the session. If you've got technical issues, please pop them in the chat, and our colleague Tamar is available to help. Our normal advice to each other is when something's not working is log out and come back in again. And I think that's always the first port of call if the sound or something is not working. But hopefully we'll have no hitches. We plan today to be, we normally have a 6-monthly employment update for academies and schools, but we planned this one thinking that we would have the employment bill, and we did. It was published back on the 10th of October. And the aim of today's session is mainly to look at the provisions of that bill and what we know now and what that's likely to mean for you all. But we are going to start with looking at some developments in sexual harassment, which we've been mentioning for a number of years and are now absolutely imminent. So starting there, I thought I'd take you through what the current law is and the change that we're about to see. So the law protects individuals from being subjected to harassment in the workplace. And so sexual harassment occurs when a person engages in unwanted conduct, which has to be of a sexual nature. And the conduct has the purpose, so the aim of, or the effect of violating their dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. I dwelt on purpose or effect. So purpose, it's intended, but effect, it might not be intended, but if it has the effect, it will still constitute harassment, as long as that is the perception of the individual who's the recipient of that conduct, and it's reasonable for them to feel that way. And I think that's really important to remind ourselves that it could constitute harassment, even if that's not the aim behind the behaviour. So at the moment, that's what individuals are protected from, and individuals are protected from being subject to harassment in the workplace, and they're also protected from being treated less favourably, so being subjected to any form of detriment because they've complained about that harassment, because they've rejected it, or actually if they've submitted to it, so they've agreed to do it, and then something's happened as a consequence. So there's widespread protection for individuals to bring claims in their employment at the moment. The claim can be against the person who's harassed them, so against the individual employee who subjected them to the harassment, but it can also be against their employer, so the trust or the school as their employer. And generally, you'll be vicariously liable for actions that your employees carry out during the course of their employment. There is a defence at the moment. And so if one employee subjected another to harassment, you would potentially be liable unless you could defend it on the basis that you'd taken all reasonable steps to prevent that employee from carrying out the harassment. We're going to come back to that all reasonable steps defence, but it's generally quite a hard standard to reach already. You would have to, it's not just enough, and it's clearly not just enough to have policies. You'd need to make sure that your staff were aware of those policies, that they'd had regular and up-to-date training. There was a case fairly recently that was quite interesting where the employer tried to rely on the defence, and the employee was questioned about the training they'd had, and basically they said they didn't really pay attention and they couldn't remember it, and the fact that it was over 2 years ago meant that the employer couldn't rely on it, which just shows how high that threshold of all reasonable steps is. But that's the law that's in place at the moment. But we are expecting a change, and it's imminent. It's in fact on the 26th of October, so Saturday, this new piece of legislation comes into force, the Worker Protection Amendment of the Equality Act 2023. This has been a long time coming, and those of you who have been attending our webinars over the recent years will be aware of this. It came really out of the Harvey Weinstein and Me Too. I included a stat there. There was a huge amount of research and consultation with different bodies to show how much sexual harassment did happen in the workplace. So that BBC research, which was from thousands of people, found that 40% of women and 18% of men had been subjected to some form of unwanted sexual harassment in the workplace. There were also quite a lot of information which showed that people found it hard to or chose not to report it. So there was widespread underreporting. And that was for a number of reasons. Sometimes they didn't realise that they could or how they needed to do it, but largely it was because they felt that the employer wouldn't take it seriously or that there would be adverse repercussions as a result of this. So all of this sort of engagement with society around workplace sexual harassment has led to this new piece of legislation. So we have a piece of law and an amendment to the Equality Act, but we also have updated technical guidance from the Equality and Human Rights Commission, and that's a really useful document that's worth a read. And they have also, the Equality and Human Rights Commission have also published an 8-step guide to help you discharge your obligations in relation to this new duty. So what is the new duty? Well, it's a positive, proactive duty, not a defensive one, to take reasonable steps to prevent sexual harassment in the course of employment. It needs to be added on to a claim that an individual is bringing. So going back to the example that and one colleague harasses another, they could bring a claim against that individual. They could bring a claim against the organisation on the basis that you're vicariously liable for that action. And they can bring an additional new claim under this Worker Protection Amendment Act to say that you have also, as an organisation, failed in your positive duty to take reasonable steps to prevent that harassment. And if they're successful in that claim, then there can be an uplift to the compensation that they receive. And that could be up to 25%. And it could be based on both the compensation for loss of earnings, but as well the injury to feelings award that they would get if they have been subject to harassment. It's important that people can't bring claims of their own volition if they're not otherwise successful or bringing a sexual harassment claim. But the Equality and Human Rights Commission does have the ability to take enforcement action against some employers. So if they do consider that there's an employer where there's a systemic issue or widespread problems, then they will be able to take action on their own account or on behalf of a number of employees as well. So what does this mean and how is it going to affect you? Well, what is really changing? We talked about there already being a good reason why you would take all reasonable steps to prevent harassment in the workplace. How does this change? Well, the Act creates this positive, proactive duty to take reasonable steps to prevent harassment. And so there is a distinction, I think, between the two. The current position is a defensive one and essentially aims to control the behaviour of an employee. You've taken reasonable steps to prevent that employee from harassing another. So does that employee know that it's unacceptable? Have you trained them on that? Are they aware of their obligations? Do you take action if they've done something wrong and made clear to them that that's what they shouldn't be doing? That's how you discharge your current duty to stop that particular employee conducting any form of harassment against another. The new duty is different in that it's about the culture that you've got in your organisation, and it's to improve the experience of all your employees. So it's a preventative duty is how it's explained by the Equality and Human Rights Commission. It's a duty to control the experience your employees have. So you've got a positive duty to make sure that no employees are subjected to harassment in the workplace. So it's about their experience rather than about the behaviour of individuals. So how do you discharge that duty? Well, sorry, I wanted to mention third-party sexual harassment before we get to how you discharge the duty. There's an interesting nuance here that throughout the parliamentary process, there was a debate about whether there should be additional protection from harassment, from protection against sexual harassment by third parties. It was in the law, it was out of the law, and actually, as it's been passed, it is outside of the legislation. So currently, the law means that you've got a positive duty to prevent employees subjecting each other to harassment. However, that isn't the end of the story, really, because you've got a duty to make sure that individuals aren't in an offensive environment. Actually, if you have a culture by which third parties can subject your employees to harassment, so in your case, maybe that's pupils, maybe it's parents, maybe it's alumni, maybe it's people who come and use the premises or hire them out, or contractors, people who are carrying out works, all of those people who might touch your organisation. If any of those subject your employees to harassment and you don't take steps to effectively manage it, your employee still could succeed in a claim, and have been a number of that where they say you, the employer, have failed to protect and create an environment that's safe for them to be, and that's in breach of your Equality Act duties. But there's no direct protection at the moment, but that is going to change, and so we're going to pick up on that later on as part of the employment bill as well. So how do you discharge this duty? What should you be doing? Well, it's currently that you've got to take reasonable steps. Again, not all reasonable steps, reasonable steps. And what's reasonable will absolutely depend on your context and circumstances, how big you are, your resources, the types of areas of risk, whether you've had lots of issues. If you have, you'll be expected to do more to stop them in the future. The 8-point reference guide that the Equality and Human Rights Commission have issued is a really useful one. And these are the 8 points that are on that guide in terms of the things that you should be doing. And I would suggest you take this away as an action list. First of all, you should have an up-to-date anti-harassment policy. You need to also engage with your staff, and that's quite interesting. They need to be obviously aware of that policy, but also you need to talk to them either in focus groups or through surveys, so that you understand, do they understand what behaviours are accepted? If they have got an issue, do they know how to raise it? Do they have confidence that if they raise it, it will be dealt with effectively? So you've got a handle on what your staff view of the workplace environment is. There's a strong onus on assessing the risks, so you should be doing a risk assessment. You should think about where there are likely to be risk areas. So if there are social occasions where there's alcohol, if people are working one-on-one, if there are power dynamics at play, if there are other situations where there's likely to be risks, you need to look at those risks and can we manage them effectively or reduce them at all. How can we make sure within our organisation that we've got effective methods to report concerns of sexual harassment? Schools will all be familiar with low-level concerns in terms of safeguarding issues. Do you adopt similar sorts of protocols and processes in relation to harassment concerns? How do you demonstrate that you manage those complaints when they come to you effectively? You need to definitely have some training, and you should think about tailored training. So you'd want some training for new staff on induction and make sure that's covered. So you'll already be covering safeguarding and code of conduct and acceptable use policies and things. You should be covering anti-harassment in that too. As well as thinking about that, you'll want to have some regular training for all your employees so they understand, again, what behaviour is expected of them and how to raise concerns. And you'll also need training for your line managers so that they effectively can intervene and refer things through the right process if they become aware or someone talks to them about being harassed at work. You might want to think as well as part of your risk assessment, or generally thinking about third parties and what steps can you do to effectively manage third parties. If it is pupils, do they sign up to a charter or some sort of code of conduct themselves, behaviour policies, which make it clear that they can't subject your staff to harassing behaviour and that there's disciplinary sanctions as a result if they do. And you do need to take stock and regularly evaluate the effectiveness of the steps that you've got put in place. So if you do have grievances or complaints where sexual harassment's upheld, you do need to make sure there's a lessons learned exercise and what steps need to be put in place to stop that happening again in the future. And it's worth redoing surveys as well on a regular basis to see how effective those steps have been. So although in some ways you might have thought this isn't a big change, there's definitely a need to take some action in order to protect the organisation. We're not going to dwell on that now, but very happy to answer any questions about that duty in relation to sexual harassment when we get to the end. But without further ado, we're going on to move on to the whole host of employment changes that we're seeing under the Employment Bill. I'm going to start with perhaps the most heralded change, and then I'm going to hand over to Ellie and Nick. So the change that will have caught everybody's eye and has been widely reported in the press is that currently employees have to have 2 years service in order to be protected from unfair dismissal and in order to bring a claim. Obviously, there are some claims, as you will all know, where they don't need that 2 years service. So if they're dismissed by reason of a protected characteristic, their gender or their race or their religion or belief, or for blowing the whistle, then they don't need that qualifying service. But for all other employees within that first 2 years, you've got latitude to bring their employment to an end. Well, that is going to go, and they will have protection from unfair dismissal from day one. There's a note there that currently this is just your employees that it will be protecting because it comes under the unfair dismissal regime, but there's talk about removing worker status. So if you have casual staff, casual workers as well, in due course, this law may also apply to them. So the principle is that the default is everybody from when they start work, not before it, but from when they start work is protected from unfair dismissal. But there will be an exemption or some flexibility where there's a lighter touch process during what's been dubbed as an initial period of employment. We're still not sure how long that initial period of employment is going to be. We think it's going to be 9 months, and that seems to be because there's been a debate as to whether it should be 6 months or 12 months, and they're splitting the difference at 9 months. And that will look and feel like a probationary process. Whether you call it a probationary process or whether you call it an initial period of employment, I think we'll have to wait and see how the guidance and perhaps guidance from ACAS and things develops, and how you move your own probationary periods to align with that as well for new staff will be a consideration as well. We anticipate that during that initial period of employment, you will be able to bring employment to an end without following your full capability or disciplinary processes, or but we'll be able to follow a simpler, streamlined dismissal process where it's likely that you will write to the member of staff with their concerns, that there will be a meeting at which they've got the right to be accompanied by a colleague or trade union representative, and potentially then there'll be a right of appeal as well. It's clear that it's not just going to be a process that you follow, but you are going to establish that there is a potentially lawful reason to dismiss. And so that could be their conduct, it could be their capability, it could be illegality. So if they don't have the right work permit or haven't complied with the safer recruitment checks, for example, or some other substantial reason, as long as that relates to them personally. What's interesting to employment lawyers is that actually if you're going through a redundancy process or workplace restructuring, actually you will need to treat your new employees in exactly the same way as those who have been there longer, and they will be protected from unfair dismissal, and you won't be able to rely on this light touch dismissal process for dismissals on those grounds. So it is going to be about having an audit trail. It's going to be about having documented the reason for moving forward in that way. And obviously we will, when we know a bit more detail, we'll be able to draft or update probationary policies to make sure they align with this light touch process. My experience, I think our widespread experience is that schools mainly have probationary periods at the moment, but often they're managed, but they're not managed really. I was going to say managed badly. That's true. They aren't really managed. And actually, it will be really important that your managers understand the need to document concerns, but also follow these processes in good time and during that initial period of employment, because once you miss it, it will be too late. So there's definitely going to be work to do around that. It will also mean that once that 9 months has passed, that actually you will need to follow your full processes in order to bring employment lawfully to an end. So if somebody is, okay and just scrapes through that 9 months, but then their performance deteriorates, you will need to effectively manage performance during that time. And we see that all the time, don't we? So actually, again, there's going to be a need to make sure that your capability procedures and your disciplinary procedures are as helpful as possible to you as an organisation, and that your managers are trained to process those effectively as possible. I'm going to hand over now to Ellie, I think it is, who's going to pick up the next suite of changes.
Thanks, Alice. So, moving on to flexible working requests. This area of employment law has been evolving, especially post-pandemic. And the bottom line is that the Employment Rights Bill is just going to make things a little bit more challenging when refusing flexible working requests. So at present, an employer is only required to deal with an employee's flexible working request in a reasonable manner. You don't have to make a reasonable decision. Under the bill, employers are only going to be able to refuse a request where two conditions are met. And one is that the statutory grounds for refusal applies. Those are the current statutory grounds that you'll be familiar with. Those still apply. And you'll also need to show that your refusal on one of those grounds is reasonable. So that second element introduces quite a change. The new requirement of reasonableness will likely introduce a much higher threshold for employers. Commentators believe that tribunals might be more likely to apply a stricter test of an objective standard of reasonableness when assessing that. So the current statutory grounds for refusal remain things like burden of additional costs, impact on customer demand, inability to reorganise work amongst existing staff, detrimental impact on performance. But you will in future have to notify the employee of the grounds for the refusal and explain why you consider that the decision is reasonable. So not just about referring to one of the permitted reasons for refusal, but also explaining why that reason applies. In addition, the bill also includes a power for future regulations to specify the steps that you should take when consulting with staff before you refuse a flexible working request. So I would anticipate a more rigorous consultation process when dealing with flexible working requests. So in practice, this could mean that you'll be a bit more cautious when denying requests, as you'll need to ensure that refusal is proportionate and reasonable in the context of the case. You may also need to review your policies and decision-making processes around flexible working to ensure that they comply with these new standards when the bill becomes law. But we await the detail of any requirements around the consultation process in due course. It is also just worth noting that the penalty for breach has not changed. So that remains at 8 weeks' pay, which is currently capped at £5,600, but a tribunal can also order reconsideration of that request. So moving on to my next slide, this is just covering the right to disconnect or switch off. And this was a right that was promised, but hasn't made it into the bill. So it was suggested that employers would have to bring in a policy to prevent routine after-hours contact, but that allowed such contact as and when needed on a non-routine basis. It's not included in the bill, but there's a next steps document which has been produced by the government, and that states that they intend to deliver this right through a statutory code of practice. Now, some commentators have questioned whether a voluntary code will be that effective for a right such as this, but there's going to be consultation about it in 2025, so we'll have a bit more detail on that then, and that detail remains to be seen at present. Right, moving on now to 0 hours contracts, so brace yourselves. This was one of the flagship policies of the Employment Rights Bill to end so-called exploitative 0 hours contracts. The bill introduces significant reforms around the use of these contracts with the aim of providing greater security for 0 hours workers. So the changes are going to shift the balance of flexibility towards employees and place a limit on the ability to use these contracts as freely as they are currently used. So the bill is going to apply to qualifying workers, and these are defined as 0 hours workers and workers on low guaranteed hours contracts. So that's to stop you getting around the legislation by having 0 hours employees on guaranteed low hours. And employers are going to be required to offer these 0 hours and low hours workers guaranteed hours where they work regular hours over a defined reference period. So there's a bit of a carve out in that the hours worked during that reference period will need to satisfy certain conditions as to their number or regularity, or as is otherwise specified in regulations, which we don't yet have. So we don't know what the conditions will be, but we'll get the detail in due course. So what is the reference period and how long is it? Again, we don't know. We'll get the detail in due course. All indications from the government suggest that it's going to be 12 weeks, and essentially the reference period will be a period worked under the contract. So it's important to know that we have the bare bones, but really none of the detail about this new framework. But the length of the reference period and other key details are going to be set out in regulations. Essentially, it means after a certain period of time, employers are going to need to offer certain workers more stability in terms of their hours. So moving on to the next slide, when the duty is triggered, an employer will have to make a guaranteed hours offer to a worker. This will either be to vary their terms and conditions of employment or to offer a new workers' contract. In the case of an offer to vary terms and conditions, the bill prevents an employer from varying any other terms and conditions other than those that relate to this right. In the case of the offer of a new contract, that contract cannot be less favourable than the worker's terms during that relevant reference period, save in very limited circumstances. The guaranteed hours contract will need to specify either the days of the week or the hours that the worker will be offered, or a working pattern and times of day that reflects the actual hours that they've worked during the reference period. Timing, the form and the content of a guaranteed hours offer will be confirmed in regulations, which are to follow. So unfortunately, we also don't have those yet. A worker will then have to confirm if they accept or reject the offer of guaranteed hours by giving notice to their employer before the end of a response period. So moving on then, the bill provides that the guaranteed hours offer can be a fixed term contract, i.e. not permanent guaranteed hours, if it would be reasonable to do so. So the burden appears to be on the employer to show this, and under the legislation, a limited term contract will be reasonable in 3 situations. The first, where the worker is only needed to perform a specific task and the contract provides for termination when that task has been performed. The second, the worker is only needed until the occurrence of a particular event, and there is provision in the contract for the contract to be terminated on the occurrence of the event. And thirdly, that the employer reasonably considered that there is only a temporary need of a description which is yet to be specified in regulations for the worker to do the work, and the contract will expire when that need comes to an end. So these provisions are intended to capture the possibility of short-term labour needs, but there is a bit more detail as to how these that's needed in terms of how these are going to operate in practice. And then on the next slide, I've just set out some of the exceptions to the duty to offer guaranteed hours. And this is essentially the obligation to offer guaranteed hours will cease to apply where there is a relevant termination during the reference or offer period. A relevant termination is a resignation by the employee, other than through constructive dismissal, a fair dismissal by the employer. So, for example, due to a diminished or cessation of work or any other fair reason. It's actually quite uncertain at present about what reasonable would be in this situation, but it could include where employees will be left doing nothing on the same pay due to fluctuating demand. And then thirdly, the obligation won't be triggered where the worker's limited term contract has come to an end and it was reasonable for the contract to have been entered into as a limited term contract. And that will be in the scenarios that's set out on my previous slide. So if the termination occurs after an offer of guaranteed hours has been made, but before it's accepted, then that offer is considered withdrawn. It's also just worth being aware that the bill does allow for further regulations exempting the duty from applying in specified circumstances. So again, we await more detail on how this will operate in practice. And a worker can bring a complaint to a tribunal if, for example, an employer does not make a guaranteed hours offer or makes one which does not comply with the statutory provisions. And the tribunal will award compensation based on financial loss, subject to a statutory maximum. Okay, so moving on to this slide about other rights for 0 hours workers. And this is another significant change for 0 and low hours workers. It's a right to reasonable notice of shifts, and employers will be required to provide reasonable notice of shifts and shift changes, including the time, day, and number of hours to be worked, and also the cancellation of shifts. So they'll have to provide reasonable notice to workers who work irregular shift patterns or under 0 hours or minimum hours contracts. And there's currently no statutory right to notice of shifts. So while what constitutes reasonable notice is still to be determined by the regulations, this could actually limit your ability to make last-minute changes, which is quite common where contracts of this nature, such as 0 hours, are used. In addition to this, for short notice cancellation or curtailment, employers are likely going to need to pay the worker for the cancelled shift so that workers are not penalised for having their shifts cut short without proper notice. Again, there's details to follow in the regulations, but compensation would be proportionate to the cancellation or curtailment of the shift in that particular case. And essentially, it just could lead to financial penalties for employers who rely on fluctuating demand and last-minute scheduling. One final thing to be aware of is that the bill also contains the power to extend these protections to agency workers. This is actually currently subject to consultation, which came out this week. So there's quite a lot of information to take in there. Just a quick summary on that area is just that employers are going to be required to offer certain workers guaranteed hours contracts after a reference period, providing workers with stability. Reasonable notice must be given for both shift assignments and cancellations, which could restrict flexibility. Fluctuating demand and seasonal work we think will be particularly affected, and the regulations will need to clarify how these situations are going to be handled. But it probably will force you to reassess your workforce planning, especially where 0 hours contracts are relied on. Unfortunately, there's just a lack of detail in the bill about how fluctuating demand will be managed. And so it's something to stay alert to, keep an eye on as consultations on regulations are released. Right, moving swiftly on then to protection from sexual harassment. This area of reform builds on the existing framework, but with some shifts that place more responsibility on employers. So Alice has covered the new mandatory duty, which comes into force on the 26th, to take reasonable steps to prevent sexual harassment in the workplace. And this bill would introduce a new duty on employers to take all reasonable steps to prevent sexual harassment. So this will be a higher duty on employers compared to the current duty to take reasonable steps. And to be clear, that this forthcoming duty to take reasonable steps to prevent workplace sexual harassment is not impacted by the bill, so that still comes into force. If the bill is passed, however, this duty will just be higher. You'll need to ensure that you've done everything reasonably possible to prevent sexual harassment from occurring in the workplace. So the bill contains the power to introduce regulations to set out what these reasonable steps are, so we can expect more detailed guidance on the kinds of policies, training and procedures that employers should have in place to meet this heightened duty, likely to include the things that Alice covered earlier: regular harassment prevention training, clear reporting mechanisms, swift actions in response to complaints. But the regulation should provide a bit more clarity around this in due course. Another reform is that disclosures about sexual harassment will be treated as qualifying disclosures under whistleblowing law. It's worth noting that a disclosure of sexual harassment is already covered by the whistleblowing framework and victimisation framework, but what it really means is these disclosures can't be silenced or hidden by non-disclosure agreements. In the past, these NDAs might be used to prevent people from speaking out about sexual harassment after a settlement, but with sexual harassment disclosures protected as whistleblowing, these will no longer be covered by those confidentiality agreements. So for now, the existing preventative duty comes into force, but it is ever more important to ensure compliance in this area. And Alice has given you a sneak preview of the next slide, which covers third-party harassment. And this is an extension of an all reasonable steps duty, which will cover not only sexual harassment by colleagues, but extends to third-party harassment of all kinds, so not just sexual harassment. So this could include harassment by clients, customers, contractors, any third party who interacts with employees during the course of their work. And it's going to therefore be a much more onerous duty than the mandatory duty that comes in this week. And the introduction of explicit protections against third-party harassment is a key element. This is going to be relevant in the education sector, where your staff are coming into contact with many different third parties. Under the new rules, employers are going to need to take proactive steps to prevent employees from harassment by third parties. And it's just something that's not currently a standalone enforceable right. So what amounts to a reasonable step in respect of third parties, in contrast to employees who you have a much higher degree of control, does remain to be seen. The bill introduces a power to allow regulations to be made to specify the steps that would need to be taken. So we will get some further clarity in this area in due course. It's likely going to involve implementing robust policies and risk assessments to monitor third-party interactions and ensure that preventative measures are in place. But it will be a directly enforceable and standalone right that can be taken by employees. So it does have more teeth than the mandatory duty to prevent sexual harassment in the workplace, which allows for the employer to be investigated or for an employee to increase compensation when they're already bringing a claim in relation to other breaches. And I mean, as Alice noted, the government has tried to bring this into law before, so it does remain to be seen whether these provisions will survive as the bill progresses through Parliament, but we anticipate this time it probably will. So I will now hand over to Nick.
Thanks, Ellie. Hi, everybody. I hope you're well. I'm going to be looking at some of the other provisions of the Employment Rights Bill, including the fire and rehire proposals, the provisions relating to unions and consultation, the family-related leave changes that are proposed, and the school support staff negotiating body. And before we dive into the Q&A, I will touch upon the draft Equality, Race and Disability Bill. So we'll start with fire and rehire. This has been a hot topic in recent years, especially in light of several high-profile cases where employers have sought to use fire and rehire tactics to alter employment terms very quickly under economic pressures. I'm sure everyone remembers the P&O Ferries controversy from 2022. As things currently stand, employers can use fire and rehire in order to vary contractual terms, provided they can point to a sound business reason for their proposed variation, and provided they follow a fair and reasonable process before making the decision to dismiss and offer re-engagement. The proposals in the bill go a lot further than I think people generally expected them to, and mark a major shift from the current legal framework. Under the bill, fire and rehire will not be completely banned, but it will be heavily restricted. Specifically, fire and rehire dismissals will be automatically unfair if the reason for the dismissal is either the employee did not agree to the employer's attempt to vary their terms and conditions, or the employer intended to re-engage the employee or hire someone else on different terms to perform the same role. As a result, employers will no longer be able to use this method to dismiss and re-engage employees on new terms without facing a high risk of unfair dismissal claims. The bill will introduce a limited exception where fire and rehire may still be lawful. This is where the employer can demonstrate that the dismissal is necessary to eliminate, prevent, significantly reduce, or significantly mitigate the effects of financial difficulties that affect the employer's ability to carry on the business as a going concern. The employer must also show that no reasonable alternatives were available. Now, this test sets a much higher bar for employers than the existing law. Under the bill, employers will need to evidence that they are in genuine financial difficulty and that fire and rehire is the only viable solution to keep the business going. On the face of it, the variation proposed by the employer will need to be a last resort in the face of an existential threat. Employers may therefore need to provide detailed financial reports and undergo significant consultation with employees and their representatives to demonstrate that the other measures have been exhausted. The requirement for proper consultation will be key. Employers will need to ensure that they fully engage with employees or their collective representatives before any decisions are made. While the bill does not prescribe specific consultation procedures, failure to properly consult will likely make a dismissal automatically unfair. The government is also giving consideration to how best to compensate employees or penalise employers for dismissals in these circumstances. Employees who are unfairly dismissed receive compensation. However, where employers have failed to comply with their collective consultation obligations, employees can also claim a protective award. The protective award is currently capped at 90 days' pay per affected employee. The government is consulting on changing that 90-day pay cap. And the government launched its consultation in relation to this on Monday and is considering two options. The first is increasing the protective award from 90 to 180 days pay per affected employee. The second is removing the cap on the protective award entirely. The second option would leave it to the discretion of the tribunal to decide the employer's penalty. So if an employer fails to adequately consult employees about proposed changes to terms and conditions, where collective consultation obligations apply, the tribunal may make a protective award exceeding the current limit, potentially in addition to unfair dismissal compensation. So where does that leave us? As it stands, fire and rehire remains lawful and the existing statutory code of practice remains in force. But these proposed new restrictions signal a clear shift towards protecting employees from being forced into less favourable terms under the threat of dismissal. Employers will need to carefully assess whether the financial hardship they claim can justify fire and rehire under these new standards, as simply stating business necessity will no longer suffice. It would make sense to ensure that any planned restructures are undertaken in advance of the new standards being introduced, and we don't expect these changes to be implemented until 2026. We are now going to look at some of the provisions relating to trade unions. First, the bill seeks to give trade union officials a wider right to access workplaces for recruitment, collective bargaining and organising, although that doesn't include organising industrial action. Access will be subject to following a prescriptive statutory process. Unions will gain a right to request access, and in response, employers will be able to either choose to negotiate the terms of legally enforceable access agreements, or the union would be able to apply to the Central Arbitration Committee, the CAC, for it to order access, with a presumption that union officials should be able to access a workplace in any manner that does not unreasonably interfere with the employer's business. The default terms for access arrangements, where the parties are unable to reach agreement through negotiation, will be prescribed in future regulations. If an employer fails to comply, the CAC would have powers to order the employer to take steps to enable access to the workplace by union officials and to impose financial penalties. Notably, the bill indicates that access will mean physical entry to an employer's premises and does not deal with so-called digital rights of access, which are another long-standing demand of the UK trade union movement. Once the bill has passed, the government will be required to publish secondary legislation setting out in detail the statutory process for requesting access, the grounds on which the CAC would be able to refuse requests for access, and the default access arrangements which the CAC may impose. The government has also promised to work with stakeholders to ensure an effective enforcement regime for unions' new rights of access. The bill also proposes reforms to statutory union recognition. The recognition process is currently complex. To commence an application for statutory recognition, a union must show that at least 10% of a proposed bargaining unit are union members and that the majority of them are likely to support recognition. The CAC can only then order recognition if either at least 50% of the bargaining unit are union members, or a ballot is held in which a majority of votes cast are in favour of recognition, and at least 40% of all workers in the bargaining unit vote for recognition. The bill proposes to meaningfully lower those hurdles by removing the 40% support threshold and the initial requirement to show that majority support is likely. The bill would also give the government the power to reduce the required threshold for union membership from 10% to as low as 2% of the proposed bargaining unit through future secondary legislation. The government will also consult on additional provisions to strengthen the existing restrictions on unfair practices during trade union recognition processes. The bill also sets out changes to the industrial action framework. Currently, in order for industrial action to be lawful, the union must organise a secret ballot. The requirements in relation to turnout and support of the ballot are currently quite fiddly. The starting point is that ballots are passed by a simple majority, so where 50 people vote, 26 are required to vote in favour of industrial action. But there are also some turnout and minimum support threshold requirements. Currently, the law requires that in order for industrial action to be lawful, at least 50% of the union members who are entitled to vote in the ballot must have done so. So, where 100 people are entitled to vote, 50 must have done so. And then a simple majority of those that voted must have done so in favour of the industrial action. In addition to this, in important public services, including education, there is a further requirement that at least 40% of the union members who are entitled to vote in the ballot do so in favour of the industrial action. So this sets a minimum level of support. So where 100 people are entitled to vote, there is the initial 50% turnout requirement, so at least 50 must cast a vote. Then there's the minimum level of support requirement, so at least 40 need to vote in favour of the industrial action, and the ballot still requires a simple majority to pass. So there's a lot of different requirements. The bill proposes to remove the turnout and minimum support thresholds to drastically simplify the requirements in place. And if that gets passed into law, that will leave us with just the requirement for a simple majority. Once a ballot for industrial action has been passed, the union needs to give notice of industrial action to the employer. Now, currently, at least 14 days notice is required. The bill proposes to reduce that period of notice to 7 days. Once a ballot for industrial action has been passed, industrial action needs to take place within a fixed period of 6 months. The bill proposes to increase that period to 12 months. The bill is also proposing to repeal the Strikes Minimum Service Levels Act 2023. This is the act under which employers in certain sectors can serve work notices on unions, identifying those that are required to work during periods of industrial action to ensure that minimum service levels are maintained. Although education is covered by the Act, regulations have never been passed to set the applicable minimum service level in education, so it has never practically become relevant to schools. The government is now proposing to repeal the Act and scrap the minimum service levels. There are a number of other key changes in the bill relating to unions and collective consultation. The first I'm going to touch upon relates to Section 1 statements. So employers must give all workers a written statement of employment particulars when they start work. Amongst other prescribed information, these must state whether there is a collective agreement which affects their terms and conditions of employment. The bill proposes to expand the list of required particulars that employers must give to their employees to include an explicit statement that workers have the right to join a trade union. The specific content and form of that statement and the obligations placed on employers in terms of when and how it should be provided will be set out in future secondary legislation. The bill also contains provisions relating to protection against detriment for taking part in industrial action. Currently, employees cannot be subjected to detrimental treatment or dismissal because of their trade union membership or activities. However, the Supreme Court, in a recent case called Mercer, found that there is no protection from detriments short of dismissal for taking part in industrial action. The bill therefore introduces new protection for workers against detriments short of dismissal for taking part in protected industrial action, correcting the gap in existing protection confirmed in the Mercer decision. It also strengthens and simplifies the existing protection against being dismissed for taking part in protected industrial action. The government is also consulting on strengthening the collective redundancy framework. Collective consultation obligations kick in when an employer is proposing to dismiss as redundant 20 or more staff within a 90-day period. The specific obligations that apply depend upon whether the employer is proposing to dismiss 20 to 99 employees or 100 or more employees. Where the employer is proposing to dismiss 100 or more employees, a statutory minimum 45-day consultation period applies. The bill proposes to double that minimum statutory consultation period from 45 to 90 days. And on Monday, the government launched a consultation on that proposal. At present, those 20 or more redundancies need to be at one establishment in order to trigger collective consultation obligations. The bill proposes to remove that requirement, and this means that trusts will need to tot up all the proposed redundancy dismissals across all of their sites within a 90-day period to determine whether collective consultation is necessary. And this is likely to mean that collective consultation obligations are more likely to kick in. The bill also proposes to introduce a new statutory role for union equality representatives in workplaces with recognised unions. Their duties would include promoting equality in the workplace, providing advice and support to union members on equality matters, and consulting with the employer on equality matters. They would have the right to paid time off to carry out these duties. The bill would also increase the existing rights of representatives of recognised unions, requiring employers to provide them with reasonable facilities and accommodations to carry out their duties in addition to their existing right to paid time off. The bill would also extend existing protections against blacklisting to cover discriminatory actions by bodies other than employers or employment agencies. The bill also contains a raft of changes in relation to family-friendly rights. The bill includes powers to make regulations to increase protection for maternity leave returners and those returning from other forms of family-related leave. Currently, staff who are pregnant or who have given birth have enhanced protection during a redundancy process, which gives them a priority right to suitable alternative vacancies. The bill proposes to give the government powers to introduce regulations to extend this protection to cover other non-redundancy dismissals taking place during pregnancy, maternity leave, or following a return to work. The explanatory note to the bill states that the regulations will ban dismissals of women who are pregnant or on maternity leave and during a 6-month return to work period, except in specific circumstances. The bill will also extend this protection to apply to other forms of family leave, such as adoption leave, shared parental leave, neonatal care leave, and bereaved partners' paternity leave. Further detail in relation to these new and extended protections is awaited in regulations. The bill also proposes to expand bereavement rights. Employees currently have a day one right to 2 weeks parental bereavement leave, and if they have at least 26 weeks service, a right to statutory bereavement pay. The bill will give the government the power to introduce a broader day one right to at least 1 week bereavement leave for employees, and regulations will specify the necessary relationship with the deceased in order to qualify, but we assume this is likely to follow the definition used in time off for dependents. The bill also proposes to make a number of other changes to the existing framework for family-related rights. Currently, anyone seeking to take parental leave needs to have at least 1 year's service, and anyone seeking to take paternity leave needs 26 weeks service. The bill proposes to remove those qualifying periods. Employees will also be able to take paternity leave after taking shared parental leave, introducing an element of greater flexibility around childcare. Now, the final aspect of the bill that I wanted to touch upon was the proposal to introduce a school support staff negotiating body as part of targeted focus on sectoral collective bargaining. This will aim to provide a structured mechanism for addressing employment matters specific to school support staff and to make the sector a more attractive one in which to work. Matters falling within the remit of the SSNB will include pay, terms and conditions, training, and career progression. And the aim is to collectively agree terms to apply to all roles across the sector. Support staff will be defined to include non-teaching employees in maintained schools and academies. The SSNB will be composed of school support staff representatives, employers, and the Secretary of State, as well as an independent chair. And agreements ratified by the SSNB will become legally binding. So the Employment Rights Bill is proposing a very broad array of changes, but what happens next? While we've covered some of the key elements today, it's important to remember that the bill is still going through parliamentary scrutiny and has yet to become law. The bill was introduced in Parliament on the 10th of October, with the second reading taking place on the 21st of October. This means that the bill will now be debated by both the House of Commons and the House of Lords before it can pass into law. During this process, amendments may be made and some aspects of the bill could change. A lot of the detail will be left to secondary legislation, which means that even after the bill is passed, we will need to wait for further regulations to clarify exactly how some of these changes will be implemented. For example, we still don't know the precise details around probationary periods, 0-hours contracts, and fire and rehire rules, and these will all be subject to consultation and future regulations. The government has outlined a timetable in its next steps document, with consultations planned for 2025. Some of those specific consultations launched this week and will run into December. This means that even after the bill passes, there'll be a period of discussion and consultation with stakeholders to shape the final regulations. Most of the major reforms are expected to come into force no earlier than 2026, so there is still plenty of time for schools to prepare for them. We'll continue to monitor the bill's progress and provide updates as more information becomes available. And for completeness, the final thing I wanted to discuss before we move into the Q&A is the government's commitment to begin consulting on the Equality, Race and Disability Bill. The government says that this bill will extend equal pay rights to protect workers suffering discrimination on the basis of race or disability. Commentators have expressed some concern over the proposed extension to equal pay claims to cover race and disability. Some believe that extending equal pay law is not an effective way to tackle race and disability discrimination, and that extending equal pay claims in this way could make claims more costly and complex, but we will see. The bill will also introduce mandatory disability and ethnicity pay gap reporting for larger employers with 250 or more employees. Many trusts will be familiar with reporting on the gender pay gap. This bill proposes to expand those reporting obligations to disability and ethnicity as well. So that's the whistle-stop tour of the Employment Rights Bill and other changes. Let's now take a look at the questions that have been raised this afternoon.
Thanks ever so much, Nick. Let's have a look. We've got a few questions in the box, but please do feel free to add them in and we will tackle them. I'm going to have to put my glasses on. Yes, the first question about anti-harassment policies. Yes, we do have anti-harassment policies and we've updated ours. So if you do have our manual or policies, get in touch and we're happy to help with that. Ellie, there is a difficult question around 0-hour contracts, which we sort of predicted. If a guaranteed offer is made, but then not worked, is the employer, oh, well, there's a couple of questions. Employer bound by a duty to pay for work that hasn't been done?
Yeah, also taking that first question.
Yeah.
I think the devil's going to be in the detail. I think we're still awaiting the detail of what form a guaranteed hours contract will take. But I suppose it's going to depend on the reason why the work is not done. So if a worker is just not turning up for the work, that's one situation. I suppose it's going to depend. I think in the case of people, I think maybe this question might be targeted at the situation where you've got an invigilator who is offered a guaranteed hours contract and then there's no invigilation work. I think that's an unlikely scenario that's going to arise because I think the legislation does take account of genuinely temporary work, and that's stated in the next steps document that the Labour government has published. So they have tried to make clear that where work is genuinely temporary, there's not going to be an expectation to be offering permanent guaranteed hours.
And that's the follow-on question, really. Could an exam invigilator be given a series of fixed-term contracts?
Yeah. I mean, I think it's going to be interesting to see, and I think we won't know until we see the detail of the regulations. It may be that it's going to become more appropriate to deal with things like exam invigilators by way of a series of fixed-term contracts. It may be that it's dealt with on a sort of assignment basis with a overarching umbrella type agreement. Anything that makes clear that it's a limited term arrangement so that it's brought within that part of the framework. But I'm afraid I can't be much more specific than that until we've got the detail.
Thanks, Ellie. And then Nick, there's a question about the support staff negotiating body and how the interplay between national and locally negotiated terms. So my understanding, but can I check with you, is that it is a national negotiating body like the school teachers paying conditions, like the school teachers negotiating body. And so in terms of then the local agreements, how that applies and how local negotiations then happen, whether they will start fading away or whether they will piggyback on the back of the national agreed terms, probably wait to be seen. Is that your understanding?
Yeah, absolutely. That's completely my understanding. So I think, yeah, it's likely that the national terms will set essentially a minimum, and it's possible for local terms to exceed the minimum potentially. But yeah, the SSNB will be a set of national terms.
We've got some questions in the chat as well. If people have got them, could they put them in the Q&A if you can see them? But I think we can probably cope with both. So there's a 0-hour contract one. It picks up on this point, but we will go through it again. 0-hour contracts and the guaranteed hours in reference periods are going to be very tricky for exam invigilators. where actually the current arrangement works well for both sides, where there are peaks of work that are offered and they're accepted, and individuals can accept them or decline them according to their circumstances. It's not really a question as much as a point, and I think we all agree that it is going to be tricky, and we don't currently know how the regime that's proposed will fit in with those arrangements. And as Ellie said, we think that there's probably going to be a way around it, where using some sort of fixed term assignment model which better reflects those sorts of arrangement. It appears, doesn't it, Ellie, that the framework for the 0 hours contracts in the employment bill look like people who are employed generally all year round and who work quite a lot of weeks or a year, generally doing a fair amount of work, but just haven't got any contractual guarantee of that. That's clearly what the government had in mind when they were drafting those provisions.
Yeah, I think it's aimed to give some more stability for those types of workers, but the next steps document that accompanies the bill prepared by the government does note that they understand that there are arrangements where these 0 hour contracts work for both parties, and the idea is that will still be available to both parties to carry on that basis. It's just managing the risk of that right arising, or the duty to offer guaranteed hours arising, which I think there is scope for in the bill.
The next question is really a bit more, sort of more of the same, but actually it's about the process of consultation, which perhaps we can answer more broadly. Nick has mentioned that we are seeing consultations already being launched, and certainly for most of these areas that we've talked about today, we're likely to see significant consultation before we then see draft regulations. So there are already some consultations going on. The one at 0 hours at the moment is very, very limited. It's about the impact with agency staff, but it seems likely, do you both think, that we may see more consultation before we see the detailed regulations? Nick, I don't know if you've got a view.
Yeah, I think we're going to see a lot of consultation over a lot of areas of stuff contained within the Employment Rights Bill over the course of the next year. So yeah, I think that's definitely likely.
And so yes, and then again, sort of a comment really about the significance of the points you discussed around trade union recognition, which is obviously widespread in the academy and maintained school sector, and industrial action, which will have a significant impact. And obviously during the previous government, we saw a significant amount of strike action based on pay, and then towards the end, ballots on workload as well. Clearly, everybody hopes that we're in a brave new world where industrial action will be a last resort. But the fact that there are some of these, changes that Nick talked about will definitely mean that if there is industrial action, it will be easier to get the support, and then there will be less notice required of it, and the mandates will last longer, really, Nick, won't they? I don't know if there's anything else you want to add.
No, nothing further I want to add. Really, that's a perfect summary of the direction of travel with the proposed changes.
And then another question about documents. Yes, we have started pulling together a sexual harassment risk assessment. So do get in touch if that's something that you're interested in. There doesn't appear to be one at the moment published by the government, but the alternative, if you're used to working with risk assessments, is to look at the technical guidance, the Equality and Human Rights Commission technical guidance, and perhaps we might include a link to that in the information that's shared after the session, because within that technical guidance, it's pretty useful. There's a whole list of things that they consider to be high risk areas, which you could use as a framework for your risk assessment in terms of identifying the risks and then looking at how you manage them using the templates that you're used to. Obviously, you will need to think about your own context and areas as well, but actually it's a really good starting point. Let me just have a look whether we've got any more questions, but I think we might have a couple. Okay, so we're jumping around a little bit. I think we've answered the one about the local and the national pay awards. Oh, Nick, how about this? Can you advise how the fire rehire ban might affect MATs responding to job evaluations at lower pay bands. So essentially where there's an exercise to reevaluate roles based on a new structure, usually following transfer into a MAT, how that might impact.
Yeah, that's a great question, and it's an area which is I think is going to be massively impacted by the new fire and rehire regime as it's currently set out in the bill. The way that the bill is currently drafted would suggest that you wouldn't be able to go through your classic dismissal and re-engagement consultation process unless the issue that you were trying to address through that process was something that was threatened the ongoing viability of the trust. So it may be that we're going to have to think quite carefully about whether there are any alternative ways of achieving what what we want to achieve. Alice, I'm not sure if you've got any other comments in relation to that.
No, it's interesting. Although obviously at the it is, although potentially it might fall under a redundancy program. And so rather than it being changing terms and conditions of employment, where it might be is that you're looking at a restructure, so a business restructure or a redundancy, so that the jobs that were currently configured and the function of those jobs has changed by reason of the new entity or the larger entity. And so that actually you're looking at it as the job that somebody was doing is no longer in existence, but there is a new alternative job on new alternative terms and conditions. But then if they didn't want that, they'd be made redundant. And that may well be the way in which, change happens in terms of looking at structures and appropriate pay rather than simply rebanding the pay. But obviously I appreciate that brings other issues themselves, but certainly redundancies and restructures will be easier to achieve than changing terms and conditions of service. I'm just going to flick between the two again and see if we've got any. I think we might have answered the questions. I'll give everybody a minute or two to put in any more while you've got us for another 15 minutes. I think we've answered everything. Yeah, I think we've come to an end. Thank you so much for your questions. We do find them interesting. Tamar has just shared a feedback poll. It would be really useful for us if you're able to complete that. We appreciate there's a lot of change on the horizon. We will continue to keep you up to date as we get further developments. I think what we'll see is that each section of the employment bill that we're covered will have consultation, we'll get more detail and we'll get regulations, and obviously we'll keep you up to date as we move through it. But there are obviously lots of changes on the horizon, and if there's anything we can help you with at any time, please do get in touch with any of us or your usual contacts in the employment team. Thanks for joining us.